Okay, so I think at this point, just want to thank everybody for being. Oh, thanks, everybody. Good to see everybody here, and we're now going to convene and call to order the Human Services Background Study Eligibility Task Force Subcommittee on Disqualification. And I'm John Geffen. And Mr. Vogel, could you do a formal roll call for quorum?
Certainly, Mr. Chair. Ms. Dawson. Ms. Dawson. Chair Geffen.
Present.
All right, Mr. Irvin.
Present.
Ms. Kaser.
Present.
Judge Kulik.
Present.
Mr. Page. Mr. Page. Representative Robbins.
Present.
Mr. Sandoval.
Present.
Ms. Sherlock.
Present.
Mr. Tatum.
Present.
All right, Mr. Chair, we have 8 members present, 6 are needed for a quorum, so a quorum is present.
And thank you so much, Mr. Vogel. First, I want to apologize to everybody in the subcommittee. I missed last week. I kind of got double booked with some kids, my kids, and I apologize to everybody, and I appreciate everybody moving forward in my absence. And I have reviewed the December 21st meeting minutes, and hopefully I'll be up to speed today. And maybe along those lines, that the meeting minutes from the December 21st subcommittee meeting were posted on the task force website, and want to ask to the members of the subcommittee whether there are any corrections or any issues with the meeting minutes as posted. I see that there are no objections, so we can certainly declare that the meetings are approved as they were distributed and put on the website. I think what we want to kind of do now is continue an open discussion, a somewhat open discussion about the disqualification laws and disqualification issues. I know that I think it was Ms. Kaser in the last meeting had identified a very important document, a 2008 report from a similar task force that looked at the disqualification laws. Not all of those fit within our little disqualification review, since we have the remedies group. I'm gonna have to wave my hands because the lights are going off in my office and they're triggered by, well, it'll just be dark. And so, I just wanted to know if people had an opportunity to look at the 2008 report. It is pretty long. There is a recommendation section that includes ideas, but is that something you think that we should go over in some detail, or have people been able to kind of review it partially? I just want to make sure we're all sort of on the same page with our discussion.
I didn't have enough time to do that. I've looked at other materials, but honestly, just the size of it, and I've been really busy on the bench, to be honest. It's kind of like, oh, save that for later. So any short form of bringing me up to speed would be greatly appreciated.
Do you think with that, I mean, just by maybe a show of hands or nods, do you think others would find that valuable, just to have maybe on the recommendation section some review of it? Okay, I see Ms. Kaser, I see Mr. Tatum nodding, Ms. Sherlock too, and maybe I'll have Mr. Vogel. Do you think you could share a screen and post that?
Certainly, Mr. Chair. All right, you should be seeing my screen now. I was scrolled down to the
You were exactly where I wanted to be.
Okay, I just wanted to make sure everybody saw the title here, but let me get back to that point. Apologies, Mr. Chair. All right.
It's a big document, and I understood what the judge said. You open something up, it says 54 pages. Like,
yeah.
Oh goodness.
And Mr. Chair, Mr. Tatum's hand is up.
Yes, Mr. Tatum.
Yeah, I was just saying you guys didn't mind if I was just showing up because I'm in the remedies group. So I don't know if that made any issues.
You're welcome here as well, Mr. Tatum.
All right.
And I'm just going to go through these somewhat quickly. Just the recommendation section. Some of them I think are really important. Some of them won't be. Mr. Vogel, you and I have to kind of figure out a way to navigate this. The first recommendation is the grandfathering in of individuals who had set-asides before the 2005 changes. So obviously there were significant changes to the disqualification laws in 2005, and this just dealt with how to deal with that. I don't see that this is a major issue in 2022 because most of these issues have been resolved. There have not been those significant changes since 2005. We can certainly open it up to discussion, but unless anybody else thinks there's an issue there, we could move on. All right, let's go to the second one. I think this is an important one. It's to reconsider the disqualification for drug or alcohol related offenses and clarify policy as necessary. I mean, I think one of the most important parts to this is that a lot of time with drug offenses, we're dealing with felony offenses. In Minnesota, trace amounts of drugs are going to be, for the most part, felonies, absent marijuana. And so if you have a small amount of cocaine or meth, you're going to have a felony if it's not diverted through a diversion program. So under the current language of the Background Study Act, any felony conviction for drugs is a 15-year disqualification, with the 15 years starting at the end of your probationary period. That's a pretty long time. And it is, in my opinion, an ongoing criminalization of addiction. And I think that there are some people that do really well and may not need to have a disqualification that could run up to about 18 to 20 years. So this request in the 2008 report was to relook at whether or not that's an intelligent way to go about disqualifications, 15 years plus any extra probationary period. So that might be one we want to talk about again. If we could go to number 3, Mr. Vogel. And I think we'll skip the A, B, and C. I think we're just going to talk kind of generally. Now they, I believe, so one of the disqualifications is involuntary termination of parental rights. And honestly, I don't remember if that's still true. At one point it was, if it was voluntary or involuntary. And maybe we'll have to look that up a little bit to see if it's still there. But obviously, some individuals involuntarily lose rights to their children. And under the law for a while, that was a permanent disqualification. And as you know, a permanent disqualification, there's no set aside, there's no reprieve. It's permanent. One of the things I wanted to take a step back to and remind people is, when we look at the disqualification laws prohibit an employer from hiring an individual, as opposed to an employer saying, like at Target, well, I see that this happened 13 years ago. I think that you're going to do a good job and I'm okay with it. So it doesn't give the employer the opportunity to make those decisions. So it is a unique process, for these types of jobs. I will do some research on number 3 and certainly shoot that back out to the subcommittee. If we could go to the next one. So this deals with this permanent bar issue. And the recommendation in 2008 was to eliminate all the permanent bars except for murder, manslaughter, and criminal sexual conduct. So it would be really culling down the permanent cases. So, the permanency cases are so important because there's no chance for a set aside. They will remain in effect in perpetuity. There's nothing an individual can do. And so this proposal was to eliminate some of those permanent disqualifications. And the idea was to move the permanent ones back to the 15 years and allow, set aside if required, but allow them to expire as well. Okay.
I want to briefly discuss criminal sexual conduct. And I realize that normally it's an easy one where we tend to toss people away permanently. But, and this is anecdotal, but I had a case recently that kind of changed my mind. I had a 31-year-old man in front of me for failing to register as a predatory offender. His offense was criminal sexual conduct when he was 11 in foster care, and the victim was another child in foster care. In the 20 years between that and him being in front of me, the only reason he failed to register is he'd been homeless and addicted for a number of times. Absolutely no assaultive behaviors for 20 years as an adult. And a child at 11, their behaviors did not render him a danger. And I realize there are predatory offenders who, and we absolutely have an obligation to protect children and vulnerable adults. But there are, I just would like to see some way for juvenile offenders, their age and circumstances to at least be looked at, perhaps, without a permanent bar.
I think that's a great point, Judge. And I mean, I think we could have a long discussion on the crim sex cases, the failure to register. I mean, we have clients that register because they were charged with an offense, but were never convicted of it, even a kidnapping offense, and still have a registration requirement. And sometimes are told that they didn't have to register, and BCA later tells them that they do. I mean, I think we got a lot of issues with it, and I agree 100% that we should be looking at it more thoughtfully, and maybe even more so within the juvenile context. And you know, I mean, anecdotally, I had a Hmong client years ago who was he was in a relationship, and his family kind of organized it. They had a cultural marriage. He impregnated his wife, but she was very young. She was 15 and he was, 20, and he was charged. He had to register, and he had only had sex with one woman his whole life. They had 7 kids together, but he's got a crim sex. So I think some thoughtful analysis of this is really important, Judge. So thank you. Can we go to the next, Will? This one is an assessment of when there's no relationship between the tasks and responsibility of the job and the disqualification. This can get and the recommendations were to determine, like, so the felony disqualifications they wanted to eliminate were some of the fraud cases: food stamp fraud, wrongfully obtaining public assistance, tampering with the witnesses, crimes committed for the benefit of a gang. And their 2008 response was, let's look at the nexus between the job and the offense to determine whether or not there's an issue. This one goes on for a bit. If you could scroll down a little bit, Mr. Vogel, you can see they went through the felonies, the gross misdemeanors, and the misdemeanors, and came up with a group to get rid of. One of them I thought immediately was disorderly house. Could you be a child care provider or work at New Horizons Child Care if 6 years ago you had operated a disorderly house? And some people think of those as sort of the drug houses. We do have cases where they're just it's a house party. So this one is just more about removing offenses that don't seem to have a direct correlation with these direct care jobs. I think there is some argument here, when you look at some of the frauds, like a food stamp fraud or issuing a dishonored check. I think one of the pushbacks had been, like, if you're going to be a PCA and you're going to be in someone's home, is there a connection between access? Because you might have access, not directly, but if you were, being dishonorable access to their bank account information, you might have access to a checkbook. So that has been some of the pushback on those nexus cases. If you could, and riot is an interesting one. We had a bunch of riot cases that came out of the Republican National Convention years ago, and people wanting to work in, they were organizers for protest and were subsequently disqualified from jobs that they had. And then this I thought was a really interesting one, is taking a look at this idea of our current strategy is permanent disqualification, 15-year disqualification, 10-year disqualification, and 7. Maybe we switch that to a 15-year, 10-year, 5-year, and 3-year and this is based on some science. The 3-year window is that individuals generally who maintain a period of non-criminal activity for 3 years, the likelihood of them recommitting goes down very dramatically. There's some age issues too, but the 3 years has sort of been used through the social science indicators as an important timeline. So if you scroll down a little bit, Mr. Vogel, you'll see some pretty detailed thoughts on what should be in the 15-year, what should be in the 10, and so on. Because what we have right now, and I'm going to skip the permanent ones, but the 15-year disqualification, felonies, 10-year gross misdemeanors, 7-year misdemeanors. So, they are just sort of, all put together based on the severity of the sentence. And this mixes it up a little bit more and came up with a strategy to have a little bit more thoughtful for 3 years. So the 3 years would be misdemeanors, dangerous weapons, insurance fraud, receiving stolen property, bringing stolen goods in the state, just misdemeanor theft, medical assistance fraud, and certainly. And maybe the other point to remember about this is we don't want to use this as our end. This was designed, I think, for us to review to figure out our beginning, because I don't think we need to be wedded to not only their ideas, but their divisions within each idea. But, and again, we're just sort of going over it all today. Let's just keep going down. This is an interesting thing. It just, instead of looking at, if you'd go up to right there, like what is, when DHS is looking at something, could they come up with a more individualized, thoughtful analysis? I think it's similar, Judge, to kind of what you're saying before, like let's look at everything and make it more individualized. And I think one of the things that's always hard is how do you come up with the right factors? How do you come up with something that gives enough discretion but can't be abused? So, but this is the previous group sort of list of factors they'd like the department, I guess, whether it's DHS or MDH or whatever the entity is that's disqualifying, to look at to determine whether or not that individual should be disqualified. And Mr. Vogel, will you keep going? I forget if there are more, quite honestly. Yeah, I think we can kind of leave it at that. Those were sort of the recommendations of the 2008 group. There are other parts to it that we could discuss, but that's I think in a nutshell what they came up with. One of the things I wanted to highlight too was one of the difficult things about disqualification law is you never know if you're disqualified until you have a background study. And what can be difficult is somebody might call me and say, am I disqualified? And sometimes I can tell them yes. Sometimes I don't know. And they can't call DHS and say, am I disqualified? There's nothing to trigger that besides an actual background study. So you end up having to do this really weird thing where you have to see if they know somebody that owns a child care center, or they have to try to get a job somewhere, volunteer somewhere. to have the background study completed. And so one of the things I'm always sort of hoping for is the department allows us for a procedure where somebody can determine if they're disqualified. And this is really important for individuals who are going to school for something in indirect services. So, I don't know how many times someone comes into our clinic and says, I was going to school for nursing. I got to my practicum, or I got to start doing my, my internship, and they said I'm disqualified. And you're like, well, that'd have been nice to know 2 years ago and $45,000 ago. So that's one of my hopes, is that we can create a mechanism where someone, and maybe they pay $20 like everyone on a background study, but can find out if they are disqualified prior to pursuing work in that area or education in that area. So I just talked for a really long time. I want to certainly open it up if anybody has any questions about the 2008 or any ideas on other issues they see as important, or if we want to flesh out some of these other ideas.
Mr. Chair, Representative Robbins' hand is up. I don't know if you can see it on your end. That's why I'm
I
interjecting with that.
cannot. So if you would keep doing that, I'd appreciate it.
Certainly.
Thank you so much. Representative Robbins, please. Oh, we've got you.
I think you're muted.
So sorry. Thank you, Mr. Chair, and thank you for the discussion we've had so far. I was interested in the point you just brought up about how people go to school and may not know they're disqualified. And I'm not sure I understand that. Like, if you fall into any of these current categories that are in statute, you, even without a background study, it's very likely you would be disqualified, is it not? So is that not something like schools of nursing or people go through with their students early on, like maybe even the first course, to say, look, here's what you have to know to be in this field? It should be sort of standard operating procedure that this is addressed. And I don't think everyone, I mean, the list is quite explicit, so you would know for the most part if you've had one of those convictions.
I would say it's not always. So the first one is, I don't think people always exactly understand. This is sad, but I think very true. They don't always understand what they went through. A lot of clients we meet don't really understand their criminal history. They're charged with something, they took a plea, and they feel very ushered through a process and come out sometimes not exactly sure. They're very sure about what the sentence is, but significantly less sure about what the conviction is. The other part to it is the preponderance of evidence piece. So you could have been charged with felony assault and taken a plea to disorderly conduct, and disorderly conduct is not a disqualifying offense. But if the department determines by a preponderance of evidence that you committed the offense, you will be disqualified for 15 years, even though you've not been convicted of it. So there's this huge piece of who knows. And that's what is very difficult for us is, or if it's in another state, it's hard to always figure out, okay, I got a so-and-so in Illinois. Well, those are different words. Which one is it in this list? I don't know.
Kevin, sorry to interrupt you, but I've got a question about that.
Sure.
So if you're charged but not convicted, the agency then makes a determination of whether they think you did it. Do you know what the standard of proof is? Or
Preponderance of evidence.
Okay, that's the 51%. And they just look at what the complaint and the
police records and the complaint.
Yeah, so the prosecution's documentation.
Yes, they don't, and
in isolation from anything else.
They do not interview a single person. It's a complete paper review.
Wow.
And the remedies section is looking at the preponderance of evidence test, which has long been a really frustrating thing for me as an advocate, because one of the problems is with the preponderance of evidence cases, you don't get a pre-deprivation hearing. You get a notice that says, even though you weren't convicted, we determined you did it. and therefore you're either permanently disqualified, 15 years to, and then when you appeal, you get an administrative appeal, but you're about 9 months out. So you've gone through an extended period of suffering, usually, in my opinion, unnecessarily, and it's a really significant problem.
And you're not entitled to a public defender for that appeal, correct?
Correct. You'll face usually an assistant attorney general, but you will be I'm on the administrative law section. I think it's 90% are pro se.
Mr.
Thank
Chair,
you.
sorry, Ms. Sherlock's hand is up. Representative Robbins is, although I'm not sure if you're just leaving yours up, Representative Robbins, and then Mr. Tatum's was up, but it's not up anymore. Sorry to single you out, Mr. Tatum.
Thank you. I appreciate the discussion, Mr. Chair. And I did have a couple more questions, but I think I'll just wait and continue to listen. Thank you.
Thank you, Representative Robbins. Ms. Sherlock?
Thank you, Chair Geffen. I just want to say I did read through all the documents, took a lot of notes for myself. I know a fair amount of this given my involvement in child foster care licensing and the background study problems we have there. I just want to say I found that the vast majority of the report is about employment. And so it doesn't really get at the needs we have in child foster care licensing. So I just want us to be aware of that as we move forward. I think there's a lot more work to be done for other people other than just people who are disqualified from employment. I also want to say that, we have the same preponderance of evidence for child foster care licensing. We have the same, levels of misdemeanor, gross misdemeanor, felony, but which is not included in the requirements of background studies for either adoption or transfers of permanent physical legal custody, which is some of the stuff I talked about last meeting. And I believe Will sent out the statutory reference that I sent. So it seems to me that if we believe permanent parents, it's safe enough to determine that they can parent permanently based on a few really egregious assaults, murders, rapes, those types of crimes, and they require them to be felony level convictions of crimes. I don't quite understand why temporary foster parents have such a drastically different standard with this preponderance of evidence, which is, in my mind, kind of crazy that you can be not even really charged with a crime and be disqualified. So I just want us to be thinking about that as well. That in some ways, the employment, and I want to reiterate everything we're saying. The time frame to go through an appeal, a request for reconsideration on a DQ, that whole process can take over a year. So that's over a year someone's unable to work at the place that they want. And what I did learn through reading this report is the ridiculousness that if you finally do go through all the hoops, and maybe the employer you went through the hoops with has said, I can't wait any longer, you're no longer employed here. But the next time they got hired, they have to go through the same process all over again versus just getting cleared. If you get a variance or a set aside, why is that not appropriate in any setting that you work in? And it can take over, and then we have kids in unlicensed relative homes a lot of times waiting for this process to go through. So there's liability issues when we have kids in unlicensed homes, and there's a huge financial impact to the counties when they have kids in unlicensed relative homes because we lose federal funding, and at some point we lose state funding. So something has to be done in this process that either shortens it dramatically, or, in my opinion, we need to make it simpler. It should not have to be this complex to get a request for reconsideration. So I just want to, as we're talking through all these things, I want us to be thinking about not making minute changes like changing from a 15-year to a 10-year period, but do we need those 3 levels? Do we need those levels at all?
These are great discussions. Mr. Lick, can you think, I mean, I really appreciated your point about when we look at foster care, it's not employment. Obviously, it's something, I mean, there's money involved, but it's not. Are there other areas, and I'll open this up to the whole subcommittee, that you can think of that fit that same kind of, I don't want to call it an exception, but it is fundamentally different. And we're dealing with kids that need people to care for them. I mean, but are there any others that you can think of? Anyone?
The closest I would say is childcare licensing, but then again, it's sort of like employment, because if, you know, that's their, foster care is not supposed to be anybody's means of livelihood.
Right.
So that's why it's not like a job that you're talking about, but it is a lot of times relatives, that we want to reduce kids' trauma and place them with relatives before we place them with strangers. But childcare licensing is sort of has a foot in both camps. It's trying to take care of our vulnerable kids in childcare settings, which we desperately need, but it's also their livelihood.
And maybe
So-
it's a logical thing to kind of think about too, is sort of separating that from sort of the job, volunteer, direct care positions. And then maybe we can add other things, because I know we're going to get Joanna Woolman from the Institute of Child, I forget, but who did a lot of the legislative work in the last session on the foster care law, to kind of give us an update and give us some guidance on where they see other areas for us to do work. But I think it's a really, really good point. Thank you so much, Ms.
And
Sherlock.
one final thing that's really helpful, because somebody will also send out information about the legislative changes in 2021 about background studies. And again, I would just say that there's some changes. It's good to have changes, but I don't think they go nearly far enough in resolving these problems that we are consistently having.
When you talked before about reconsideration, you know, so when a case comes to us, generally an individual is disqualified, and then you can request reconsideration on one or two bases. One is, hey, I shouldn't be disqualified, you're wrong. And the other one is, okay, I am disqualified, but I don't pose a risk of harm, please set that aside. When you're
Yes.
talking about those delays, Mr. Leck, do you see that more on the set aside request or just the whole process?
Well, I mean, just to put my 2 cents in here, this is what I find. Anytime someone has a hit on their criminal, when we do a background study, and if they have no hits, nothing on their background study, it comes back pretty quickly. If they have any sort of hit at all, and it doesn't have to be a high level DQ, if they have anything for DHS to sort all that out and decide, what were they charged with? What were they convicted of? What was the crime, et cetera? That takes a very long time just to even get the DQ. Then we have 30 days to get, the person who is disqualified has 30 days to request reconsideration. And then after that, DHS can take 6 months or longer to respond to that request for reconsideration. And then once they get a response, the person gets a response on their request for reconsideration. That starts that appeal process formally through a hearing with an administrative law judge. And then it can go up to the district court, appellate court, Supreme Court. So all of that process takes, I mean, I'm being generous, I think, when I say a year. Tiffany, you do this work too. Does that sound
Yep, we have
about what
I would
happens?
agree. We have some relative foster parents who have been waiting, and now you added like the COVID stuff, right, on top of it, right? That they've been sitting in, a child's been sitting in an unlicensed home for over a year. We can't move towards permanency or finalizing anything. Potentially, they might not pass the background check, and then we have to look at moving that child. And this child's been settled and living there for a year or more. So it can be a very long, frustrating process.
I'll also mention that if the person that's the subject of the background study has ever lived out of Minnesota in the last 5 years, the time frame to do all of this has been doubled. So it's a very, very arduous, long process. And most people don't have the wherewithal to take this on themselves. As you mentioned, they're unrepresented. At the department, we try really hard to help relatives through this process to request reconsideration. And the state does want to hear the county's recommendation on that, whether we think that they should, set aside or issue a variance. But it's a lot of hoops, it's a lot of difficulty, and I'm certain that people just give up through the process.
I think we can say they do. One of the data sets that we have requested from DHS is how long are each of these stages taking. And the law is pretty clear about what they're supposed to do. Historically, they haven't been able to make the timelines. They have sort of a couple options. One is to get it done. The other one is to say, hey, we need more time letter. But that doesn't, it rings a little bit hollow to some of our clients. It just says you need more time, but it's not a stagnant environment that they're in. There's something very pressing going on, whether it's employment or foster care and so on. I mean, one issue I would note though is when we deal with the reconsideration process, and we knew that this was not a great perfect break, but that is in the remedies group. The remedies group is dealing with reconsideration. And so I think what we could do is make sure that we are communicating with them on that, because I can see in Mr. Lackman's case, you guys, and a lot of the systems want to be in both, and kind of our work overlaps into both. And I want to make sure that we get updated enough, and maybe we start talking about that at our next full meeting on the 14th, how to make sure everyone knows what the other subcommittees are doing, because I think we have some information and some insight that could be beneficial. So please continue to remind me and others of that if we forget. One of the things I think has been, there are a couple things I think about, when we talk about administrative hearings, there are really in Minnesota there are two types that are relevant to this. There are these things called fair hearings, which are conducted by the Department of Human Services. And that's a lot of the cases we're talking about. But the Office of Administrative Hearings also does something called contested case hearings. And those usually arise when there is one of two things: money. So let's say a child care facility gets fined because there's maltreatment, or the person's a state employee, then they're entitled to an administrative hearing by the Office of Administrative Hearing. And so within the Office of Administrative Hearing, they have a strict requirement that they have to conduct a hearing in 90 days. And the only one who can kind of waive that would be the appellant. So if I'm an individual that's aggrieved by the department, they have, from the moment I request it, they have to give me a hearing in 90 days. And if they don't, the only way they can extend it is on my request. They also have, for all temporary actions, they have an expedited process that is done within about 30 days. So it might be something we think about too, is whether we communicate to the remedies group any thoughts on timelines on the hearing end, in addition to the reconsideration. And on reconsideration, and this is my personal opinion, not on the set aside request, but on the straight reconsideration, I think it should be good. I think we should, I'd like to see it just go away. I think it's unnecessary delay. We see almost no cases on reconsideration overturned, none. And in fact, I stopped years ago putting much time into it, because I would spend hours on it, and then you get something postmarked the same day saying no. And it struck me as this is not a remedy at all. And if we're going to get to a hearing, let's get to a hearing, and let's have a neutral decision maker make the decision, and let's not tread water and sort of force those people to quit. And so that's something I'm going to recommend that the remedies group look at, is what is the benefit of reconsideration? If somebody asks me to reconsider something, I say no. I made my decision. Why would I reconsider it? But I'll take any pushback on that.
To clarify, you're talking about a request for reconsideration as a specific request to the department to change their mind about the decision that they made on the DQ in the first place, correct?
Yes. Yes.
Because the way I think about it, and this may be wrong, but request for reconsideration is an overall umbrella term for either to request a set aside or a variance. So are you talking about a set aside, a variance, or neither of those things? Because
Neither.
those are before it would go to a neutral third party.
So would I request, like, let's say that we get one of these preponderance of the evidence cases, and they say, we think based on the preponderance of evidence, your person committed assault, never convicted. And then I can say, no, you're wrong. I'm requesting reconsideration on whether this person should be disqualified. And my experience has been the department doesn't overturn those, but I've just wasted 60, 80 days knowing I'm just going to get knowing my client's going to be denied. So I would like to separate a request for a set aside or a request for a variance from a request for reconsideration of the underlying merits of the disqualification.
Do you ever do all three of those things at the same time?
Yes. Well, not the
Okay.
variance. Usually when we do it, the variance has to be requested by the employer. So for us, it's almost always just going to be requests on the correctness of the disqualification and a set aside.
That's a little different than we do in child foster care licensing. We
I think
kind of
so.
request it all at the same time. The person who has the DQ and the county weighs in, and then they respond often to say, no set aside, no variance. But a lot of times they do say they will issue a variance. But they're not the same as employment. That's what I was talking about. Like, that report's very different because we're not supervising anyone on a variance. It sounds like employers have to supervise people when
So,
they
yeah,
have a one who has a variance. That doesn't happen in our area.
So the set aside cannot come with any additional anything. It can't say, we're giving you a set aside, but this person's going to look over your shoulder and write reports back to the department every month. A variance could do that, but a set aside is just yes, no. And if it's yes, it's just you're like everybody else. With a variance in the other worlds, only the employer can request it.
Mhm.
The employer has to identify what measures it's going to put in place to safeguard people in its care. So it's a separate one, which I think is a
Thank you.
further reminder why Ms. Sherlock and in this case, so we should kind of carve out a little bit of this second group when discussing these things, because not everything applies the same. One of the things we were talking about, Mr. Vogel and I were talking about prior to today's meeting, was coming up with some of the ideas and then sending them out in a list and have the subcommittee kind of weigh in. Doesn't need to be, so formal, but which ones that the members think are important, just so we can start to have some type of hierarchy of what we think we should be focusing our next discussions on, both with an educational piece and then with ideas for change, if any. Are people open to that as a way to move forward, or I would certainly embrace any other ideas? I see nodding heads, and that makes me happy. So I don't know if we need anything else. I'd love to hear too from somebody that went through some of these things. If anyone has any kind of lived experience, I know that I would shudder to try to put somebody on pressure on them. But if anybody's gone through this, their own personal experiences would be really, really helpful, I think, for the group to understand. Is anybody willing to share any of their? Mr. Sandoval?
Hello, can you hear me?
We can. Thank you so much.
Yeah, excellent. Sorry, getting situated here.
No problem.
So yeah, no, I've definitely experienced some of these challenges firsthand. When you're going through the list of things, there was a couple of things that I personally related with. The misdemeanor for work for protection violation. I've got some domestics on my record from back in my drinking days. And the hard part about that was that I had permission to be at the residence because at the time I was with my son's mother, and she had to go to work. So I was at home watching our son, but still, and taking ownership of my part, I was in violation. So, but to not understanding, I guess, the consequences that would later have effect on me. And I guess I kind of use that as an example to kind of segue into, my story. So I grew up in a very dysfunctional setting. My mother was an alcoholic. My father wasn't in the picture, and just dealt with a lot of trauma growing up, I guess, just to summarize it. And early on, I started to experiment with drugs and alcohol. I, started out drinking and smoking weed, and was just getting into trouble from an early age, juvenile detention center, and it just continued to progress for me. I wasn't able to identify the issues that I had. I was just trying to cope, I guess, and carried on into my adulthood. My drinking progressed. I moved on to harder drugs, and I have a felony domestic assault on my record that I was under the influence at that time. And you mentioned earlier kind of like how the system will just it's like a motion. You kind of just go through it and, they're all right, plead to this and we'll get you out of here today kind of thing, not really knowing what consequences I would really be facing with that, 5 to 10 years later. And so, that situation was, I had smoked about 2 ounces of crack, haven't touched it since, but, and I fell asleep for 2 days and woke up and just got into this huge blowout with my son's mother. It was a very unhealthy relationship for both of us. I was just under the influence, and things that I'm not very proud of today. That's definitely impacted me. But the root of all of it was my drinking and my drugging. Like I'm a completely different person when you remove all of that out of the situation. And even after that, I continued to struggle in and out of jail, and prison, and treatments, and finally, my last incident was first-degree drug sales for cocaine. I was dealing cocaine, and I went to treatment. I went to Teen Challenge, and that was in 2012. And I've been clean and sober since then. I celebrate 10 years of sobriety in April 19th. And,
Congratulations.
Thank you so much. And I've just completely turned my life around. I'm married. I'm a homeowner. I've got great careers going for me. But it was really heartbreaking and frustrating coming out of treatment. When I was trying to get hired on to help other people like me, and I couldn't because of the things that are on my record, and they're all chemical dependency related. I think my domestic holds me back from more than my actual my first degree drug charge in some cases. And so there's some things on there that I know are far worse charges than mine, and mine is a permanent disqualification, but I want to say there's lesser or more severe charges that have a 5-year or 10-year or 15-year, that I don't even have that opportunity with my charge. And so I don't know, it was very hurtful, heartbreaking, and it'd be good, even not for me. I'm in a different space in my life now where, I went on to get my real estate license, and I own a snow plowing business. And so I'm in a different space now, but even if it can make a difference for those, behind me that are trying to turn their lives around and want to help people in a similar situation, even if to make a difference with one person would be an honor. And I like what you said earlier about doing like like an internal review or pre-review before having them, jump through all the hoops, because I was able to do that with the Department of Commerce, where they made me jump through a lot of hoops to get my real estate license. I'm probably one of the very few in the state of Minnesota with a record like mine that has the real estate license. And I had to go to each courthouse and print off each criminal complaint, sentencing orders, character reference letters, had to put all the package together to get to them and to try and find out before, I went through the schooling and the time and the investment to get them to kind of let me know. So I think that's a really good idea to have some sort of a process in place for something similar like that. But I've continued to prove and show people when they give me a chance that, like, I'm going to prove them right. Like, I'm going to make sure that I do my part. And so I know there's a lot of people in recovery with that mindset of just kind of honoring second chances. And so, yeah, that's kind of, I guess, my perspective in this whole thing. And hopefully we can make some differences. There's a lot of things on those lists that is just surprising to see as barring people. But I don't know, I would be interested if there was some way to, when reviewing these processes, if it is drug or alcohol related, that, with proper recovery and, character reference letters and completion certificates, and, someone to vouch and say, hey, yeah, this guy, you mentioned something with the 3-year, where reoffense is much less likely. I just think that all of that should be considered, and maybe it's a case by case scenario, but I've just been I was held back from being able to. I had a job working. I spoke in over 600 presentations in high schools and middle schools, sharing my story, encouraging youth to think about their choices when it comes to drugs and alcohol. And I was no longer able to continue doing that because of the things on my record. So I've done everything I could to try and make a difference, but it's just been even held back in a lot of that. And my mother was battling cancer a few years ago, and I resigned I was making 6 figures in the automotive business, and I was a sales manager, and I was resigning to take care of my mother. But I with how much I'm disqualified from everything, I doubt I would even be able to, sometimes family members can take care of their family members and just receive a small compensation to kind of make ends meet and get through. But man, I had to scrape and claw and do what I had to do so that I could be there for my mom and, still pay my mortgage and still kind of get by. So I've had it affect me in a lot of different ways, I guess, for something that happened, gosh, it was 2011, maybe even 2009, something like that, like long time ago. And it's just continued to impact me. And so I don't know, it'd be nice if there was a reviewing process that would take these things in, like credibility and, consistency, take these things into consideration for people that are turning their lives around. And I guess that's what I hope to help accomplish. So.
Well, I just want to say thank you so much, Mr. Sandoval. I mean, for telling us your story and sharing that with us. And, I just think it's fantastic. if you were not permanently disqualified, do you think you would be doing more to support your community? What would you do, you think?
Yeah, in fact, I was nominated to apply for a director position at Teen Challenge for alumni director. And like, who better to serve the alumni than, you know, somebody who's coming from there, been there, and still hanging in there. And you know, I believe I was not chosen because of my background, and they don't want to deal with the disqualification. You know, I can't be around the clients. So, because even though you know, I thought maybe, oh, dealing with alumni, they're not technically clients, you know, but there still would be some mingling of the clients. So they altogether just kind of I felt like I was kind of dismissed. And it's my situation, nothing against them, you know, they don't want to deal with it, but you know, it's just, you know, if I can help change that and, you know, help people to be in these positions, you know, whether it be employment, whether it be foster care, whether it be, you know, helping sick parents, all of it. Like, I think it's all valid, and just everything, generally speaking, needs to be reviewed, even if it's, you know, going through each one of them. And does this work? What do we think about this? What do we think about this? And yeah, so I think my life would be, you know, I'm grateful for on that, doing very well. But I do think I would definitely be more involved if I wasn't held back. Yeah.
Okay. Well, thank you again so much. That is so helpful. Mr. Irvin.
So, Leo, thanks for sharing your story, and maybe you have a new advocate on your side after telling your story today. I am the Vice President of Human Resources at Minnesota Adult and Teen Challenge. And my story comes from a totally different perspective, but it's also not without its challenges. Addiction often hits people because of their environmental situation, the situation that they grew up in. That was not the case for me. And it didn't become an issue for me until later in life. And I was an executive at the Toro Company, where I worked for 25 years and had a wonderful career there, and then became addicted to cocaine myself. And eventually I was arrested and charged with a felony drug crime. And I pleaded guilty to that. And as a result, I had responsibilities at Toro for human resources worldwide, but knew right away that I wasn't going to get a job in human resources based on my own background. So I went to work in a different field and spent 7 years working in something unrelated, not anywhere near as fulfilling, and spent 7 years speaking myself to high schools, colleges, churches, community groups on decision-making and the notion that a drug addiction or an alcohol addiction doesn't necessarily just show up in certain environmental situations or certain neighborhoods, that it is very undiscerning and can impact people's lives no matter where they are or where they came from. And so 4.5 years ago, a recruiter called me and said, somebody gave us your name as a candidate for this job. And I had no idea whether or not my background would preclude me. It was an opportunity to look at an HR job. I went over and met with the recruiter. They didn't know about my background, and I shared it in the interview. I went forward, met with the president. He didn't know about my background. I shared my background with him during the interview. He said, thanks for sharing that. I want you to meet with a couple of my vice presidents. I met with them. I shared my background. They said, great. Hopefully we'll see you again next week. 2 weeks later, I had a job offer. And in the job offer, it explained that I'd have to pass a DHS background check, and nobody ever explained what that was. And so I went online and read the whole thing myself and read 245C, Section 15, and read through all the disqualifying crimes. And I called up both the president and a guy that is on my staff and said, I'm not going to be able to pass this background check. I have a 15-year disqualification. And they said, we're not worried about it. And it took 7 months before we heard back. And after 7 months, I was disqualified. And so I submitted an application for reconsideration, and in a week received a set aside. And so I've been working there under a set aside for 4 years. And in the course of my working there, I look at people like Mr. Sandoval's background. And when I got there, we do a private background check, and we look at that, and then my staff will come to me and say they won't be able to pass the DHS background check. What do you want to do? And more often than not, I will say, let's process them anyway after we talk to them and find out what the circumstances are. And I've learned a lot about the background study laws, where they're problematic, where they're, I think, unfair. One of the crimes in there, I think, may be permanent disqualification, is domestic assault. And so I will interview somebody to find out what actually happened and what is behind that. And it sounds like, we can't bring somebody in that has domestic assault and put them with our clients, because we need to protect the at-risk population of our vulnerable adults. And then I'll meet with somebody and say, what happened? And the last person I interviewed said, well, we were doing meth. My cousin, my girlfriend, and I went in to take a shower. I came out, and my girlfriend and my cousin were smoking my meth. And I got in an argument with them, and my cousin got in my face, and I reached up and grabbed him around the neck and threw him back on a couch, and he called the police. And now I have a first-degree domestic assault on my record. And he said, I've since gone through treatment. I understand what I did was wrong.
That's exactly my situation too. Someone got in my face, and I kind of gave them a push away, and I've got a felony domestic, and sorry to interrupt you, but
I know that DHS will not give us grace on that, but I was able to hire that guy in a non-client facing role. And so the taking away all of the discretion and taking away an employer's ability to interview a candidate and to find out the circumstances. And I understand a judge having their hands tied when they have a criminal case in front of them. I think it should be different if a person has been through treatment, has served their punishment, and has shown a period of both remorse and good decision-making. But oftentimes, this statute by itself doesn't allow for that. And it's one of the reasons why I'm on this committee. I think I'm an example of where just looking at the paperwork doesn't apply. I think hearing Leo's story would be compelling in that he deserves a second chance. And so frankly, that's my whole purpose in life right now is to try and ensure that people who've made mistakes have an opportunity in front of them to stand on their own 2 feet and do something worthwhile with the remaining years of their life. So, John, I appreciate your leadership of this, and Representative and Judge, being on this committee is so heartwarming to me to look at people wanting to make positive change. So that's my story. I appreciate being on the committee, and thanks for listening.
Well, thank you so much, Mr. Irvin. I mean, we're just appreciative of you and your time and you sharing your story too. And
Thank you.
I appreciate you and everything you're doing as part of this committee. Um, Representative Robbins.
Thank you, Mr. Chair, and thank you, Mr. Irvin and Mr. Sandoval, for sharing your stories. That it was really helpful to me. But my question goes back to, and congratulations to both of you on your sobriety and success. It's just so inspiring. And I've known and been a fan of Teen Challenge for many years, and it's just great to see the continuing fantastic outcomes that the difference they make in people's lives. I just want to go back to something Mr. Sandoval said about how he went through a Department of Commerce check to verify whether he would even qualify for the real estate license before he went through the training. And I just wondered if Mr. Vogel could maybe look into for us what that process is, and if Commerce already has it figured out, maybe that's something we could recommend to DHS or to the colleges themselves to, like, here, put this in your first course. Because I do think it's, frustrating for people to go through all the training and really want to have these careers in these fields and then to find out after the fact. So I think that would, if there is a process already in place in some other department that's working, I would like to learn more about how they do that. And perhaps, Mr. Vogel, I know you're already very stretched, but if you could look into it for us, I would appreciate it.
Certainly, Representative Robbins.
Yeah, I agree with that too. It'd be nice to not have to reinvent it and see how other agencies do it. I would say, Representative Robbins, we used to reach out to a lot of the schools that were training, and we just couldn't get much traction on getting them up front to do the background study. And it felt at times that it just wasn't financially beneficial for them. So they didn't. I mean, and that's a horrible thing to say, but it felt like, hey, yeah, that's not our deal. They'll figure that out with DHS. I mean, it seemed like it should have been a requirement for to even participate in the program, but there's no law that says it, and they, almost uniformly don't do it. And we got, I really just so many calls on that issue. And some of them were hard to figure out, like those preponderance of evidence cases. Some weren't. Some were, a domestic from 2 years ago. Like, this person was clearly going to be disqualified, and nobody really told them. And I think their position was they need to do their own work, but it didn't make any sense for anybody to spend all that time and money and be let down. Not that all education isn't good.
If I might, Mr. Chair. And I agree with that. I'm not sure we need something in statute telling the universities to do it, but I think just making them aware of this, they may not be aware of the issue, and also making the courts aware. I think it should be really kind of back in the lap of the courts to have a sort of when the sentencing is given, that they explain the disqualification rules and what that means. I think somehow maybe having some of the onus put back on the courts to make sure people understand what the plea bargain means for them, understand this. I mean, with all the electronic records now, I'm sure this is something we could put an addendum to on every sentencing form, and at least people will have been notified. So I think it's not only a DHS issue. I think we have to look at the other pieces in the system.
I agree. And I think historically, and I'm going to have to pick on my own profession, attorneys have not done a very good job. And some of it might be in self-interest too. You want to get the plea and you want to get it on the record, and any discussion of collateral consequences seems to hinder plea. But I think we need to do a much better job, both with the defense attorney, the prosecutor, and the judges, to make sure everybody. And one of the problems is the collateral consequence umbrella has just gotten so big. There's disqualifications, but I think there are a couple hundred different types of collateral consequences that can result nowadays. from a plea agreement. So there's a lot, but we need to do a better job and need to figure that out too. So I appreciate that. What I was hoping to do, respecting everybody's time, was have a little discussion just briefly about how often we think this subcommittee should meet. And I think then what we'll do once we have an idea of time is send out another poll and figure out when people are most available. And, we don't want to give you subcommittee fatigue and have you meeting with us every 3 days, but we are on strict timelines and we want to continue to move forward. We want to continue to have thoughtful discussions. So does anybody have an idea or a suggestion how often the subcommittee should meet?
I'm pretty flexible, so whatever majority can do, I can piggyback on it.
I appreciate that. Anybody? So it'll be every day at Mr. Sandoval's house. He's gonna make us lunch, dinner, whatever he says. He's making it all for us. He's a host. I'm new to this a bit. So is it every 2 weeks? Is it every 3? Like, any suggestions or input would be appreciated on this. Again, I want to respect your time and not wear you out, but I want us to not have to every time we meet go, what were we talking about again? Yes, Ms. Kaser.
Thank you, Chair Geffen. I think it depends a little bit on what we would hope to accomplish each meeting. So, I think if we really wanted to hammer in on, for example, one of those recommendations and really look at it like that number, I think it was, it was the 5th one, that they looked at all those offenses. That could take a couple meetings, and I would probably want to do those close together so we don't lose traction.
Okay.
But so like once a week would make sense to me. But if we're still kind of trying to figure out, or we need time to do some homework on our own outside, then 2 weeks between meetings would make more sense to me, given people's busy schedules.
Would it make sense to us to get something on the books every 2 weeks, and then if we need to sort of supplement in something when we have some, like you identified in this case, one of those in-depth topics, and then we'd switch for a short amount of time or a 1 week to a every week?
That makes sense.
Are people available generally to work on this every other week, once every 2 weeks? Anybody feel that is too onerous on their time, and Mr. Sandoval's cooking isn't up to snuff and they don't want to participate? And maybe that's something you could always share with us too, that if it's too much, we will certainly take what you can give us. Mr. Vogel, do you think we could do a poll on trying to figure out every 2 weeks what day and time makes the most sense? I was thinking we'd block an hour and a half, and maybe some days we only need an hour, but if we need it, at least we'd have it.
Certainly, Chair Gaffen. Just to talk about timeline for the initial meeting, well, the next meeting after this, then the full task force meeting is next Friday on the 14th. Would you and the members envision meeting the week after that, or this upcoming week as your first? No, I'm sorry. That's a silly question. It'd be 2 weeks from now. Yes, right.
Correct.
Okay. Yeah.
And we'll cut Mr. Vogel some slack since he's jet lagged from traveling all over Indiana to Minnesota today. Does anybody else have any?
So when we say 2 weeks, is that insinuating the 18th?
We're going to just make sure that works, and make sure, like, if that date doesn't work that week, is what we're going to look at. Maybe it's going to be the Monday, maybe it's going to be the Tuesday, Wednesday, whatever is most available, if that makes sense.
I may not be available that week. I'll be in Florida.
Florida's still got internet. You can do it.
Yeah, well, I participate in a flag football league in the Twin Cities here, and we have a team going to the World Tournament to represent Minnesota and Florida.
Fantastic.
And so I won't really be by my computer much. Otherwise, I just jump on my computer from Florida. But yeah, set whatever works best for everyone, and I'll just try and jump in if I can. But if I'm not present, that's why.
And if you're not, we'll certainly make sure that you're updated on anything you missed through the meeting minutes. And if you need to give me a call or whatever, we'll make sure you're updated. Are there any other items of business that we need to discuss prior to adjourning the meeting? Okay, well, I just again want to thank everybody, specifically Mr. Irwin and Mr. Sandoval. Thank you guys so much. Your stories and experiences will always be the most important thing in guiding us in this process. Thank you again. And with that, we are adjourned.
Thank you.